Let's start with number one. Bear in mind that the so-called Protect America Act that was stampeded through this great body in August provides zero statutory protections for Americans traveling abroad from government wiretapping. None if you're a businesswoman traveling on business overseas. None if you're a father taking the kids on vacation to the Caribbean. None if you're visiting your aunts or uncles in Italy or Ireland. None even if you're a soldier of the United States of America in uniform serving overseas. The Bush administration provided in that hastily passed law no statutory restrictions on their ability to wiretap you at will, to tap your cell phone, your email, whatever, once you are outside the borders of the United States. The only restriction is an executive order called 12333, which limits executive branch surveillance to Americans who the Attorney General determines to be agents of a foreign power. That's what the executive order says. But what does this administration say about executive orders? An executive order cannot limit a president. There is no constitutional requirement for a president to issue a new executive order whenever he wishes to depart from the terms of a previous executive order. Rather than violate an executive order, the president has instead modified or waived it. Whenever the president wishes to depart from the terms of a previous executive order, he may do so, because an executive order cannot limit a president. And he doesn't even have to change the executive order or give notice that he's violating it, because by departing from the executive order, the president has instead modified or waived it. So unless Congress acts, here is what legally prevents this president from wiretapping Americans traveling abroad at will. Nothing. Nothing. That was among the most egregious flaws in the bill passed during the August stampede, orchestrated by the Bush administration. And this OLC opinion shows why we need to correct it. Here's number two. The president, exercising his constitutional authority under Article 2, can determine whether an action is a lawful exercise of the president's authority under Article 2. Yep, that's right. The president, according to the George W. Bush Office of Legal Counsel, has Article 2 power to determine the scope of his Article 2 power. Never mind a little decision called Marbury versus Madison, written by Chief Justice John Marshall in 1803, establishing the proposition that it is emphatically the province and the duty of the judicial department to say what the law is. Does this administration agree that it is emphatically the province and the duty of the judicial department to say what the president's authority is under Article 2 of the Constitution? No. It is the president, according to this Office of Legal Counsel, who decides the limits of his own Article 2 power. The question whether an action is a lawful exercise of the president's authority under Article 2 is to be determined by the president's own minions exercising his constitutional authority under Article 2. Mr. President, it really makes you wonder, where do they get these people? You have to be smart. You have to be really bright to get a job within the Office of Legal Counsel. How can people who are so smart be so misguided? And then it gets worse. Remember point 3. The Department of Justice is bound by the president's legal determinations. Let that sink in a minute. The Department of Justice is bound by the president's legal determinations. Mr. President, we are a nation of laws, not of men. This nation was founded in rejection of the royalist principle that the king can do no wrong. Our Attorney General swears an oath to defend the Constitution and the laws of the United States. We are not some banana republic in which the officials all have to kowtow to the supreme leader. Imagine this in another context. Imagine a general counsel to a major U.S. corporation telling his board of directors, in this company, the counsel's office is bound by the legal determinations of the CEO. The board ought to throw that lawyer out. That is very probably malpractice and perhaps even unethical. Wherever you are, if you are watching this, do me a favor. The next time you are in Washington, D.C., take a taxi some evening to the United States Department of Justice. Stand outside. Look up at that building, shining against the starry night. Look at the sign outside. The United States Department of Justice. Think of the heroes who have served there. Think of the battles fought. Think of the late nights, the brave decisions, the hard work of advancing and protecting our democracy that has been done in those halls. Think about how all that makes you feel. Then think about this statement. The Department of Justice is bound by the President's legal determinations. If you don't feel a difference from what you were feeling a moment ago, well, I guess congratulations, because there's probably a job for you somewhere in the Bush administration. Consider the sad irony that this theory was crafted in that very building by the George W. Bush Office of Legal Counsel. Mr. President, in a nutshell, these three Bush administration legal propositions boil down to this. One, I don't have to follow my own rules. And if I break them, I don't have to tell you that I'm breaking them. Two, I get to determine what my own powers are. And three, the Department of Justice doesn't tell me what the law is. I tell the Department of Justice what the law is. Mr. President, when the Congress of the United States is willing to roll over for an unprincipled president, this is where you end up. We should not even be having this discussion. But here we are. I implore my colleagues on both sides of the aisle, reject these feverish legal theories. I understand political loyalty. Trust me, I do. But let us also be loyal to this great institution we serve here in the legislative branch of government. Let us also be loyal to the Constitution we took an oath to defend from enemies foreign and domestic. And let us be loyal to the American people who live each day under that Constitution's principles and protections. We simply cannot put the authority to wiretap Americans whenever they step outside America's boundaries under the exclusive control and supervision of the executive branch. We do not allow it when Americans are here at home. We should not allow it when they travel abroad. The principles of congressional legislation and oversight and of judicial approval and review are simple and long-standing, and Americans deserve their protection wherever on God's green earth they may travel.